Hey everybody, welcome to a new episode in season 3 of the POSHpod. And no surprises, I have with me my co-host Bishen Jeswant, who is a partner in the employment law practice at Cyril Amarchand Mangaldas, and I'm Laxmi Char, co-founder at Parity. For those of you who have not had the pleasure of going through the first 2 seasons, I would strongly recommend go ahead and check out those seasons and what we've been talking about, because today I'm taking the conversation forward, Bishen, and I specifically want to focus on, one element of what happens if an aggrieved woman chooses to raise a complaint, chooses to, raise an FIR with the police, right? The Act says the organization has to cooperate. What does that actually mean when it comes to the nitty-gritty of cooperation?
Sure. So let's break that down, Lakshmi. The first obligation here is to assist the woman in filing a complaint, right? That's the obligation the Act puts on you, to say that if the woman wants to file a complaint with the police, the employers are obligated to assist her in that process. So the cooperation there is the employer helping the woman file a complaint.
Yeah.
Right. And so just to give a little bit more color there, so there can be 2 parallel processes that are happening. There will be a criminal proceeding happening, through the police and then the courts. And then there could be a POSH process happening. And I think we've discussed on a previous episode how the standards of proof required for the 2 are very different. They can run in parallel. You can have the IC find an individual guilty of sexual harassment and the courts find him not guilty, and that's perfectly fine because there are different standards of proof. The IC follows what is called preponderance of probabilities, which is effectively the chance of something having happened is more than it not, whereas the courts follow a higher standard for criminal matters, which is beyond reasonable doubt. So there can be a difference in finding, and that's perfectly fine. If you fired somebody for sexual harassment simply because the court held him not guilty later, that doesn't mean you need to hire him back or that the process run by the IC is wrong. So that's just to put some context there. The next part I think will be the meat of the discussion today, which is the extent to which an IC and an employer needs to cooperate with the police, because we all do know that there is an obligation under the POSH Act to maintain confidentiality, of all the proceedings before the IC and the names of parties, etc., all the evidence that is available, etc. So considering that, how is it that an employer and the IC must cooperate? So now the short answer is that the employer and IC must cooperate, because it would be absurd if there was a provision in the Act to say that you must help the woman file a complaint and then the employer doesn't need to cooperate, because that would defeat the entire purpose of that provision. So the employer needs to cooperate, and the reason for why an employer needs to cooperate and the IC needs to cooperate also comes from law, which is the Criminal Procedure Code, which is now modified under the new laws, right? There's the BNS and the Nagarik Suraksha Samhita, etc. So there is the changed laws, but for the purpose of this discussion and for convenience, because we all refer to it as CRPC, I'm going to just go ahead and use the term CRPC. Even though the law has changed, the meat of it remains the same. So the CRPC gives the right to courts and the police to seek evidence or seek information from parties who they think could contribute to the investigation, right? Now, this is not, there isn't a very high standard that has been set out here. Even if there is something desirable to an investigation, they could seek that information from any person, not only the person who's filed a complaint. So it's not that if a woman files a complaint, the police can only seek information from her. They can seek information from any person who they feel has information, documents that are desirable to the investigation. So they can definitely come, to the IC and to the employer to seek information, and the IC and employer will be compelled to cooperate. I'll just pause here to see, Lakshmi, how you've dealt with in these situations, some employers' apprehensions in this respect, since you sit on ICs, and then I'll talk a little bit more about how an employer can cooperate.
Yeah. So a couple of interesting situations that we've experienced in the past, right? One is the local thana, right? Somebody from the police station comes to the office and says, hey, we've received this complaint and, we want to meet such and such person and we want this information or whatever. So how does the HR, typically it is HR who tends to be the face of these kind of interactions. So how does the HR deal with someone just asking for this information? And based on obviously conversations that you and I have had, we know that there is no legal requirement for an organization to accept a verbal communication, right? And turn stuff over. And then the second thing that has happened, and again, I'd love to hear your thoughts about this. When the IC is approached, and we know, as you said, that these things can happen in parallel. There is a 90-day limit on the IC investigation. Typically, what we found is that the IC investigation, even though both the FIR and the complaint is kind of generated around about the same time, the IC report tends to be prepared faster. And, there is a request sometimes that, hey, if the IC has already gone through all the effort of, getting the witness depositions, collecting all of the IT related information and stuff like that, does the report just make it easier because all of this information is in one place? So that's kind of what the IC, the presiding officer of the IC and the organization also are kind of mulling over.
Yeah, I think both very fair points, Laxmi. One is, you're right that if a police officer comes and asks for information verbally, you don't need to provide it, right? Even the provision of the CRPC that I was referring to makes reference to a summons by a court or a written order from the police. It's in those situations that you need to provide the information to the, to the police or the courts, as the case may be. So that's definitely true. But that's it. The information that is available with the IC is of varied forms, right? Like you said, at the end of the, investigation process, when there's a report, it's all collated in one place. That's true. But that collated information, you can actually think of it as evidence and the findings of the IC, right? Now, there is no way that an IC can refuse to part with the evidence because the police or the courts will require the evidence to run the investigation, right? So there is no breach of confidentiality in sharing that information with the police or the courts. But the other part of it, the findings of the IC, which is even things like statements of witnesses and the report itself of the IC, arguably that on the basis of confidentiality, you can object to sharing with the police in the first place, right? Okay. Because the police is bound to do its own investigation. The police, and like you said, the process of run by the police often takes longer than the process run by the IC, and therefore, and it's only because of that the police will even have the benefit of being able to ask for the report of the IC, right? So that's only a matter of chance. So that should not be a reason why the police have a right to access the report. And just for the benefit of everyone listening, like Laxmi said, the IC process usually takes about 90 days, and that's a timeline under the Act. And the police process involves first doing an investigation to prepare a charge sheet and file charges, right? And it's only after that there is actually a hearing before courts when the matter, both parties are heard. So, and that process often takes, there's no way to put a number, but 8-9 months. So much longer than the 90-day period. And after that charge sheet is filed, then the matter goes before court. So just to come back then, so then in 3 months, the IC has a report ready with it. And the report, you can potentially argue, is not to be given. We have nevertheless seen cases where the police have gone to courts and asked for the report to be given, and the court has said, provide a redacted form of the report without the names of parties and, hiding some information. So that's possibly one way to deal with it as well. And there is, of course, a matter of opinion here, and maybe it's not right of the courts to seek that information, and the jurisprudence and practical aspects of this are still developing. So there's no firm position that we can take here, but I think the takeaway is that there are two kinds of documents that the IC will possess. One is evidence and one is witness statements and reports. And the evidence, which could be emails or messages, recordings, CCTV footage, of those the documents and information of that nature, you cannot and should not withhold from the police. That is part of your obligation to comply. The rest, maybe there is an argument to be made.
So two things that you raised, which kind of, you know, I think are interesting to pursue. One is the whole concept, because the Act says very clearly in terms of the IC is responsible to keep the information shared with it confidential. So therefore, on the basis of a written communication, whether it is from the police or the courts, the IC can share, but there is no requirement to answer a verbal question. So that kind of, puts that to bed. The second bit, which would be interesting, I think, again, to, our listeners who are either on the IC themselves or may be interested in joining an IC, can a member of the IC be made a party to the court proceedings? Can an aggrieved woman, when she does choose to take it up, bring the IC or the employer along with her in some shape or form? And, is that something that impacts people's ability to serve on the IC?
Yeah, so the short answer here, Laxmi, is yes, and I'll elaborate a little bit. But before that, I wanted to also address the point you were making earlier about the police guys approaching HR and then the HR cooperating. So maybe an employer and IC also designates who will cooperate, because strictly sharing information with HR could also be a breach of confidentiality if the HR is not on the IC, right? So you may then want to restrict the number of hands the information passes through by ensuring that the point of contact for the police is a person who already has access to information, which may say be the presiding officer on the IC or the external member, whoever you determine. Then there's fewer hands through which the information passes through, meaning there's less chance of breach of confidentiality obligations.
That's a
just
good
to touch
point.
upon that. Yeah.
So
to come back to your point about whether the IC member can now be made party to court proceedings, the answer is yes, because there is an appeal mechanism under the Act, and like we've discussed previously as well, there are multiple forums to which you can go, courts and tribunals in some cases, and designated authorities in some cases under the Act. So there will be court proceedings where decisions of the IC are challenged. And so, yes, an IC can be made party, and if you are part of the IC, you will also be part of those proceedings. But I think the important thing to remember here is one, no IC member is being made personally a party to any proceedings, right? It is only the IC as a whole that's being made party. So there is no personal liability which can arise out of these proceedings. And the harm here is more likely in the nature of administrative inconvenience as opposed to personal liability. And even in terms of, legal costs, the IC is the employer's IC, and most likely the employer will bear the legal costs over there. So there are no legal costs, neither is there personal liability. And sitting on the IC, you are doing something which is a statutory action and should be something that you definitely do. So the fact that there could possibly be some court proceedings and administrative inconvenience should not put you off from doing the right thing.
Phew, that's good to know. And then the other point is that, honestly, the statistical significance or the probability that the woman is going to go to court and take the IC with her is quite low, right? So this should not really be, this is kind of and as you were talking, Bishen, I was thinking of serving on jury duty in the US, right? Where a jury of peers are being called. And if you get, as a citizen, if you get jury notice, it's almost a sense of pride that you are part of this bigger judicial system. So being invited to be on the IC is kind of like an acknowledgement of you, the person, you, the mature leader, you, the role model of workplace culture. So on that cheery note, Bishen, I'll let you go for now, but I'm going to bring you back. We're going to talk some more. Thank you so much for your time today. Listeners, do let us know what you think. Would you be interested in serving on the IC? Is this something that you'd like to explore? Talk to us. Do you agree with us? Let us know.
Bye, everyone. Thank you for listening in. Tune in for the next episode. Bye-bye.